Thanks for joining us today to discuss the intersection between the industrial law concept of redundancy and the workers' compensation concept of reasonable management action. I'm a partner in our insurance and risk team, and I spend a good part of my day advising employers and their insurers on workers' compensation claims. In that role, I'm often the first person an employer speaks to once they've received a common law damages claim. Obviously, that's a stressful time, and employers typically have many questions. Questions about the process, questions about the likely outcomes, and questions about the costs involved. But the thing that I see time and again is questions about the interaction between workers' compensation law, which is my playground, and industrial relations, which is definitely not my playground, with many questions relating to issues surrounding the termination of the employment relationship. And so often the relationship between workers' compensation law and IR law is a difficult one, with some tension and some mismatch between the two concepts, which makes strategic decision making difficult. So when I read the recent decision of Scott and the Workers' Compensation Regulator, which looks at the concept of reasonable management action, a construct of the Workers' Compensation and Rehabilitation Act 2003, in the context of redundancy, which is intrinsically an IR-based concept, I was straight on the phone to my IR phoner friend, Adele Garnett, to get a better understanding of what that decision means for employers. Adele is a senior associate in Hopgood Ganam's workplace and employment team and fills her days advising employers in relation to all manner of industrial relations and employment-related issues, including enterprise bargaining, terminations and redundancies. So I'm very pleased to have Adele here with me today to co-present on this topic. To start, we'll give you a recap of the reasonable management action exclusion and the concept of redundancy, followed by a deeper analysis of those concepts as set out in Scott against the Workers' Compensation Regulator. And finally, some practical takeaway points. So first, a reasonable management action refresher. Section 32 sub 5 of the Workers' Compensation and Rehabilitation Act states that a psychiatric injury arising out of reasonable management action taken reasonably is excluded from the definition of injury. That exclusion is in place to ensure that businesses can make reasonable management decisions and enact those decisions without fear of lawsuit. Management action, of course, does not encompass every interaction between an employee and an employer. To borrow the words of Deputy President O'Connor in the matter of Reid against the Workers' Compensation Regulator at paragraph 10, management action contemplates a particular type of action by an employer and something more than the mere requirement that the worker perform his or her duties. A similar concept can be found in Section 5A of the Safety, Rehabilitation and Compensation Act, which is the Commonwealth Workers' Compensation legislation. That section excludes from the definition of injury one which is sustained as a result of reasonable administrative action, taken in a reasonable manner. The Commonwealth legislation uses administrative action in place of management action, but the concept is the same and we can take guidance from the Commonwealth case law. In particular, administrative action is described in the matter of Commonwealth Bank of Australia and Reeve at paragraph 31 as it is not action with respect to duties that the employee is employed to carry out that is the subject of the exclusion, but action with respect to the employee as employee and his or her employment relationship with the employer. And that's exactly what redundancy is. It's an action by the employer to bring about a change to the employment relationship. That is, the termination of the relationship. So it seems that on its face, redundancy is precisely the type of action that is the subject of the exclusion in Section 32 sub 5 and is designed to be protected by that exclusion. Let's look now more closely at the concept of redundancy before we consider the interaction with reasonable management action and redundancy.
Thanks, Anna. So what is redundancy? For private sector employers in Queensland, redundancy is defined in section 389 of the Fair Work Act 2009, which is the Commonwealth Act. So there's basically three concepts within this. The first one is that a person's dismissal was a case of genuine redundancy if the person's employer no longer requires the person's job to be performed by anyone because of changes in the operational requirements of the employer's enterprise. And then the second requirement, the employer has complied with any obligation in any modern award or enterprise agreement that applied to their employment to consult about the redundancy. And then the third requirement under point 2 there is a person's dismissal was not a case of genuine redundancy if it would have been reasonable in all the circumstances for the person to have been redeployed within either their enterprise or with an associate entity of the employer. So that's the basic summary of what we need to understand for today's purposes. One point that I really want to make clear is that 1B there, which is about awards and enterprise agreements and the obligation to consult. All awards and enterprise agreements have clauses which require employers to consult with employees in cases of major change, and they describe the obligation to consult and how it should be undertaken. It really is an essential part of the process, any redundancy process, that an employer refers back to what the actual requirements are in those modern awards or enterprise agreements and follows that to the T. And as will be seen in the Scott case, as we're discussing later, it's best to always assume that these consultation clauses apply if you're in any doubt about whether you need to consult. In terms of the risks, potential Fair Work Act claims and other claims, there are really 4 different types that we're looking at. The main one is an unfair dismissal, and that needs to be made within 21 days of the actual dismissal to the Fair Work Commission. If an employer can show that a case was a genuine redundancy, which goes back to the definition I was just talking about before, then they will be exempt from being able to apply for an unfair dismissal. So basically those 3 requirements again, the job not required to be done by anyone, they've complied with their consultation requirements, and there's no opportunities for redeployment. So if an employee can show that the redundancy didn't meet all 3 of these criteria, then it's not considered to be a genuine redundancy. And therefore, they can then go on to the next step in that process of trying to argue that their dismissal was harsh, unjust and unreasonable. Employees can get up to 6 months' pay through an unfair dismissal, although typically the compensation is a lot less than this. Another risk of claims is under the General Protections application regime for adverse action. So in this type of claim, an employee is showing that dismissal is for some kind of ulterior motive. So for example, for some discriminatory reasons, so because they were female, because they were old, because they had a disability or an illness. Or another way might be that they've actually arguing that they've been made redundant because they had some workplace right that they've exercised. So maybe a right to parental leave, or they've made a complaint in their workplace or something like that. And now because they've done those things, they've been dismissed. The third type of claim is a discrimination claim, which is similar to the one before, basically that they've been chosen for the redundancy because of some kind of attribute that they have. So again, the sex, the age, race, anything like that. And then lastly, the other type of claim which I've got written there on our slides is a breach of an award or an enterprise agreement in relation to consultation processes. So this is usually tacked on to a different type of claim. Most employees don't make this purely just this type of claim. But basically, because awards and enterprise agreements have these requirements to consult, if an employer doesn't consult, then they may be up for some kind of civil penalties. So one important thing that Anna's already talked about is that there's nothing to stop an employee from making both one of these claims under the Fair Work Act and at the same time pursuing a workers' compensation claim. And so that's why we really need to be keeping our eye on both types of claims when we're managing a redundancy process. Thanks, Anna.
Thanks, Adele. So there's quite a lot of things to keep in mind if you're looking at making an employee redundant. Let's have a look now at the facts in the decision of Scott so that we have a practical example of how those concepts of reasonable management action and redundancy intersected in that case. In Scott, the worker had been an employee of the employer organisation since 2003 and he'd occupied a supervisory role since 2010. He'd had time off work in 2018 and 2019 for a long-term medical condition, which was not work-related and therefore was not the subject of a workers' compensation claim. During the time that he was off work ill, he became worried about his job security, and he reached out to the employer about that issue. In response, he received correspondence from the employer that put his mind at ease as to his job security. However, shortly after returning to work, he was called into a meeting by the employer where he was made redundant immediately. And it was after that that his psychiatric injury, which was the subject of his workers' compensation claim, ensued. A relevant question for the Commission was whether Scott's redundancy was reasonable management action taken in a reasonable way, such that it fell within the exclusion under Section 32 sub 5 of the WCRA. Without stealing Adele's thunder, I'll give you the spoiler. The Commission went to great lengths to determine the basis of Scott's employment and decided that it was under the relevant EBA, which imposed a consultative mechanism with regard to matters raised by the employer to increase productivity, efficiency, and competitiveness of the business. Clearly, a budget-based decision to make Scott redundant fell into that bucket. However, the Commission also found that even absent the EBA requirement for consultation, there might be circumstances particular to a worker which would require consultation and make a failure to do so unreasonable. In this case, these included Scott's length of service, his earlier concerns about his job security, his long-term illness, and the supervisory role that he held with the employer. The Commission noted that the lack of consultation meant that the redundancy came as a complete shock to the worker. Now I'm going to hand over to Adele, who will give you some more information about the consultation requirement.
Thanks, Anna. So this decision went into a fair amount of detail about whether consultation was required under the industrial instruments. And the employer argued that the employee was not covered by the enterprise agreement and was not covered by a modern award, and therefore consultation was not required. When the Commissioner, however, considered whether the employee was covered by looking in detail at the position requirements and the coverage clauses of the instruments, the Commissioner found the employee was in fact covered by both the enterprise agreement and the modern award. Look, this is a fairly common mistake. I regularly advise employers who do not know whether particular employees are covered by their enterprise agreement or by their award. And it can be very difficult in some instances to determine whether someone's covered. In this case, the Commissioner went into quite a lot of detail determining percentage-wise how much of the role was supervisory, how much was on the job, also considering the wording of the provisions really carefully. I have personally spent many hours as an experienced employment lawyer determining whether particular positions are covered by awards or by enterprise agreements, which has included looking into the history of particular instruments and case law that addresses coverage clauses. Obviously, it's not ideal that it's not simple to determine this. However, we're in a situation where we are what we are, and the point is that if you're in any doubt about whether someone is or isn't covered, it's much safer to just assume that they are covered and consult. This case is somewhat unique in that the enterprise agreement was very old. It was more than 12 years old, so that the consultation clause was quite unique. However, in around 2009 and over the following years, most awards and enterprise agreements now have a fairly standard consultation clause inserted into them, such that the consultation requirements are usually very similar for all positions. Therefore, if an employer is unsure about whether the employee is covered by a particular award or an enterprise agreement, it's fairly simple to just look up any award, look at what that consultation process and follow that. And you really do need to follow the consultation process to a T, or that's where you can come undone. Consultation in relation to possible redundancy doesn't need to be lengthy necessarily. It can actually be completed in a week or even less in some instances. We would usually recommend that at the least an employee meets with an employer to provide the employee information about the proposed changes in writing, gives the employee a few days to consider and think about the redundancy, and also to get any advice if they would like any. And then 2 to 3 days later, meet with them again to genuinely consider any of the feedback the employee gives, and then make a final decision in relation to the ongoing employment or the possible redundancy. One interesting point that was made in the Scott case, which Anna alluded to before, it went beyond the requirements in the Fair Work Act. And in that case, it was held that consultation should have occurred as a part of reasonable management action, even if this position was not EBA or award covered. In some respects, this was particular to this case because Mr. Scott was such a long-term employee who had recently returned from sick leave and who'd been given assurances of job security. But nevertheless, it speaks to my general advice in relation to consultation, which is that it's always best to consult with employees in cases of major change, particularly redundancy, and it usually only takes a few days, but it can save a world of pain both at the Fair Work Commission and also in work cover claims. So what should employers consult about? So generally, any feedback that an employee has in relation to the redundancy needs to be genuinely considered. It can't be a tick and flick. So this may be ways to consider to mitigate their losses, other potential organisational structures, potential even for the employee to reduce their hours or the ways they work, whatever the employee might like to raise. But it is important to remember that it's not a right of veto over what is actually a business decision. One really important thing to consult about is redeployment opportunities. And this speaks to that third requirement of the redundancy that we were talking about earlier. This looks like an employer saying to the employee either something like, I don't have any jobs available at the moment unless you can think of something. And then the other alternative is, these are the jobs we have available at the moment. Are you interested in any of them? Do you have the right skills for them? In this case, Mr. Scott unsuccessfully tried to argue that he should have been offered a different position, one that was already filled by another employee, even though it was of less pay. The QIRC found that spilling another position that was already filled is not required, so he was unsuccessful in this argument. But as a side note, the QIRC did note that it was important that a person be offered all positions that were available, even if they were of lower paid or a different location or seemingly unsuitable for some reason. This then allows the employer and the employee to have the open discussion about whether it is a suitable job for them. This point is consistent with unfair dismissal cases. An employer should not assume that an employee is not interested just because a position is lower paid, because that person may, because of their circumstances, actually be interested in any event. An employee can also be offered a higher level position, but it's up to the employer to decide whether they might be suitably qualified with a reasonable amount of training. In another case, which is M against Allianz Australia Services, Pty Ltd, it was held to be reasonable to directly tell an employee that they didn't think that she had the technical ability for a certain role that they were putting in instead of the old role. And the Commissioner particularly noted that it was important to do this so that the employee didn't get her hopes up. Another interesting case highlighting the importance of this genuine consultation in relation to redundancy, which I've got on the slide there, is SSX Services Pty Ltd versus the Workers' Compensation Regulator. In that case, the employer wanted to redeploy Mrs. Granger to a sales position where she had previously been in a non-public facing role. Ms. Granger raised concerns about anxiety that she faced whenever she had face-to-face meetings with customers, saying that she was not good at recognising faces, she was not good at sales, she didn't easily remember visual information. However, they insisted and they offered her training. She continued to refuse and express concerns, and as a result, she suffered a psychological injury. It was held by the QIRC that this was not reasonable redeployment and that they should have consulted better and actually listened to her concerns. So just moving on, the next thing is, when should consultation occur? When should it commence? Again, it's important to refer back to the relevant industrial instrument on this one. As I said earlier, the clauses in awards are generally the same, and they generally refer to the idea of when an employer has made a definite decision to introduce major changes. It is interesting to note that in this case, the Scott case, just looking at the bold wording there, it says, this inherently requires the employer to discuss proposed changes with and to genuinely consult affected employees before the definite determination has been made. So this is a tricky one because there's obviously an intersection between employment law and workers' compensation. However, the preferred view generally, in my view, is actually that you should go with what's in the award consultation requirements. If you do a really good job of consulting with someone once a definite decision has been made, then I think you're unlikely to come unstuck at the at the workers' compensation. However, the Scott case does suggest that there may be particular reasons why you might want to consult with an employee earlier. For example, if you are conducting a wholesale review of the department or the workplace, or if there are particular considerations about that employee, like Mr. Scott returning from sick leave recently. Also, just as a side note, if you're consulting under workers' compensation laws, then you need to actually consult as part of the decision. And this came out most recently in the CFMEU case at the end of last year, which was in relation to them implementing the policy in relation to mandatory vaccination. So that was CFMEU and Mount Arthur Cole. Okay, two more points before I hand back to Anna. One other point that was made in the Scott decision was about contributing factors to the redundancy decision. And in this case, it was about his unaddressed performance. So there was complaints about Mr. Scott's performance. And this really goes to that point that we talked about before about the genuine redundancy, whether the job does not need to be done by anyone, and therefore whether the redundancy decision was genuine and reasonable management action. We said that in the Scott case that one of the things that made the general manager actually look in more detail at Mr. Scott's role was the fact that he had allegedly been handballing his job duties to the day and afternoon shift operators and hadn't been keeping up with some of his administrative functions, such that his duties were reduced. The Commissioner remarked that there was no clear evidence that this had ever been put to him and never given him an opportunity to respond, and that this then contributed then to the Commissioner's decision that the redundancy decision was unreasonable. Usually you should speak with the employee about concerns in relation to performance as they arise. And this allows the employee the opportunity to respond or improve and address concerns if they can. Ideally, redundancy should not be used as a de facto performance management process. This part of the decision is also similar to another decision that I've got up on the slides there, Bifalco versus Return to Work South Australia. And in that matter, the employer realised that there were significant deficiencies in the employee's skills and performance, but these weren't actually discussed with the employee. They did, however, commence a large-scale organisational restructure, partly due to this, which staff were not consulted on. The review ended up recommending a streamlined structure, and following the review over the next 2 months, management redesigned Mr. Bifalco's position without speaking with him. And in the end, the new position was actually very similar to Mr. Bifalco's old position. However, it required a higher level qualification. Mr. Bifalco was essentially made redundant because he didn't then have this higher qualification. It was held that a redundancy based on this, where the employee had not had an opportunity to respond to concerns or an opportunity to provide input into the process, was not reasonable management action. One last point, which is fairly straightforward really, is about this misrepresentation of employment security. So in this case, there were a couple of times when Mr. Scott was led to believe that his employment was safe when in fact it was not. And again, this is in the context of where he was worried about his employment security due to his length of absence from his illness. Unfortunately, because there was no early consultation, there was no discussion with Mr. Scott about performance. And there were then also these misrepresentations. This resulted in the redundancy being a really big shock when it came in August, when he was made redundant on the spot. And all these cases seem to point to the same thing, which is the actual termination should not come as a big shock. There should be at least something pointing to the possibility of redundancy in order to allow the employee to make time to make preparations. Thanks, Anna.
Thanks. So the things that Adele has just spoken to you about really relate to the first limb of the reasonable management action exclusion, and that is the substantive reasonableness of the management action. But there are two limbs to the exclusion, and both need to be satisfied for the exclusion to apply. The second limb is the requirement that the management action be taken reasonably, and as you've probably guessed, that relates to the process rather than the substance of the management action. The employer in Scott fell short in relation to this limb also. In particular, the worker was not notified of the purpose of the meeting in advance and was not offered the opportunity to have a support person at the meeting. Now, the calling of meetings often comes under scrutiny in the context of the reasonable management action exclusion, and so I think it's worthwhile having a look at some of the surrounding case law in that regard. Now, I know there may be very good reasons not to give too much notice of the purpose of a meeting. We all have stories of the employee who, immediately prior to termination, deleted a whole lot of important emails, stole confidential information, or maybe just ran around poisoning the well with other employees. Despite this, we have had clear and consistent guidance from the Commission that the failure to notify the purpose of a meeting and offer a support person is not reasonable. So I want to give you a few recent case examples because this comes up so frequently. Imagine yourself in this situation. You're calling a meeting to discuss suspension of a worker pending the results of an investigation. Do you A, give them notice of the purpose of the meeting and offer a support person, or B, ask them to the meeting without notice and only offer a support person once the meeting is underway? Now, I can see the allure in not notifying the purpose of the meeting in case the worker attempts to throw out the results of the investigation. But if you picked B, you're not alone. You made the same decision as the employer in the recent decision of Mayer against the Workers' Compensation Regulator. In that case, the Commission found that although the decision to suspend pending the results of the investigation was reasonable, the way in which it was achieved was not. The failure to provide notice and offer a support person meant that otherwise reasonable management action was not taken reasonably, and the exclusion in section 32 sub 5 could not apply. That decision can be contrasted with the decision in Queensland Nurses and Midwives Union against the Workers' Compensation Regulator. That is a 2020 decision. It was appealed, but the initial decision was upheld on appeal. In that one, it was found that it was not necessary to offer a support person to an executive level employee in a meeting about mutual separation. I should say that I feel that that decision stands alone. It related to an executive level employee and was in circumstances where that employee had previously raised the option of mutual separation. She also had a fair bit of notice of the meeting and the purpose of the meeting, such that she had taken advice on that topic. And she could have arranged a support person during that time if that was what she desired. I think the more consistent approach has been to require notice of the purpose of the meeting and the opportunity for a support person. And that's what I would roll with if I was organising that type of meeting. This was reiterated in another recent decision of Grace against the Workers' Compensation Regulator. Now, when it comes to support persons, there's often a debate about whether you have to proactively offer a support person or just give the worker enough information so that they realise that they might need one. One benefit of offering a support person is that you're a bit more in control of the process. You can specify that it be a person external to the organisation if that's what you would prefer. You can also require notice of the identity of the support person and be prepared accordingly. I'm sure many of you have had a situation where the worker's support person turns out to be their best friend, who's also a barrister, and it's nice to be on notice of that situation if that's what's going to happen. So the Scott decision really is consistent with the surrounding case law relating to the calling of meetings And the takeaway points from that part of the case are to provide notice of the purpose of the meeting and to offer a support person, whether that's proactively or simply by letting the worker know that a support person may be required. Now, if we just recap, I'll ask you, Adele, to distill it all down into a few key takeaways.
Sure. So the key takeaways, the first one is be confident that the redundancy is actually genuine. So don't mix it with performance concerns that have not previously been addressed. The next one is we have talked a little bit about almost all of these cases have been single position redundancies and they can attract some greater scrutiny. Third point there, really important, know what the relevant consultation requirements are, and if in doubt, consult. And even if you're not in doubt, it's better to consult anyway to ensure that you are doing some reasonable management action. The next one is decide when the consultation process should commence, whether it should be right when you're starting to think about organisational restructure or at the point where you've made the definite decision. And that is to a large extent based on either what the consultation clause says in your industrial instrument and alternatively just generally the circumstances that you're in. The next one is, and this is a bit of a no-brainer, be very careful about what communication you have with employees about employment security if there is an even slight possibility that their job might be reviewed. The last one there, so reasonable management action when conducting meetings. So the first one is give notice of the meeting and purpose. So I would normally, when you're giving notice of the meeting, just say to the employee, we want to have a meeting to discuss your employment. So something very generic without actually saying this is a meeting to discuss you being made redundant. And usually I would say give approximately 24 hours notice at least. This is really to allow them time to get a support person. The next question there is that support person, don't forget to offer the support person. So it's not good enough to just allow them time to get the support person. You actually need to say to them, you may want to get a support person for this meeting. And if you do, then they should be someone who's external to the organisation, if that's your preference. And also please let us know who they are so we can make appropriate arrangements. This support person one is different. Under the Fair Work Act, the requirement to have a support person is really about the requirement to not say no if someone wants to bring someone. However, under this reasonable management action that we've been talking about, you actually need to proactively allow the person some time to find a support person if that's what they wish to do. Okay, I think we might have a little bit of time for some questions, Anna.
So the first question we've got here is, what do I do if after giving notice of a meeting, the worker asks for it to proceed immediately because they feel too stressed waiting for the meeting date?
This is a bit of a tricky one, and Anna and I were talking about this kind of scenario a while back, and the question is, again, that intersection between fair work requirements and workers' compensation requirements. Ideally, at the point when you offer them the meeting, you as an employer are all ready to go. So if the person says, I'm so stressed, I just want to meet, you can. But we all know that there are circumstances where that's not possible. And for example, I was dealing with an employer recently where they just didn't quite have all of their information ready to give to the employee at that point. We were still working hard on it. We were almost finished the letters, but we hadn't quite finished them. So it wouldn't have been a good idea to have met with them and not provided all of that information at that point in time. In which case we're going to go back to the employee and say, I'm sorry, we're just not ready, but we'll be ready tomorrow. Or another circumstance might be that one of the management team is just not available at that point in time because the meeting's scheduled for the following day. In which case, again, you might say, no, sorry, we need to delay. However, I guess the ideal circumstance is if an employee says that and you're ready to go, then you go ahead and do it. Essentially, the employee is saying they're waiving their right to having notice of the meeting. You might want to clarify with them saying, well, this means you can't have a support person with you. Are you sure you don't want to delay? Or can you quickly find someone who might want to meet? But if they say, no, I want to go ahead, again, they're waiving their right to a support person. So I think it would be unlikely that you would be held held to have acted unreasonably in that circumstance.
I think from a workers' compensation perspective, in fact, I would go a little bit further and say that if you have an employee who's saying, I'm feeling stressed, you're on notice that they're at a heightened risk of a psychiatric injury. And so to decline that opportunity to bring the meeting forward and perhaps alleviate that stress may be viewed as being unreasonable. I understand your points about perhaps if you're not quite ready for the meeting. I think ideally you would be completely prepared for a meeting before you notify the worker of the meeting. I guess the other issue can be, as you say, having the correct management staff available to come into the meeting at short notice. If you find yourself in a scenario where the worker says, I want to bring this meeting forward to right now, and you can't have access to all of those relevant people for the meeting, I suspect the best thing to do is to say, look, we'll try and get everyone together as soon as possible and do this meeting for you as soon as possible to alleviate the stress. But it is important that these key personnel be here, and if we can't have them here, then we will have to proceed at a time when they're all available. I think if you've taken reasonable steps to have them all available, you won't be criticised.
Thanks.
Another question we have here is, what do I do with employees in terms of their work during the consultation process?
So I think Anna alluded to earlier about the possibility of once employee is on notice that they might be made redundant, that there are potential issues in the workplace in terms of them stealing confidential information or anything like that. Look, the usual process that we say is we tell an employee to go home, we'll pay you for the next few days, get some advice if you feel like you need to, have some time to think about the information we've given you about the possible redundancy, and then come back again in a few days. So it's really a stand down with pay. And at that point, I would often consider telling them things like, if anybody contacts you, then you should tell them you're on personal leave. You cut off their access to emails and things like that so that they can't do any damage to your internet systems. And in saying that, you say to the employee straight away, this is not a secret. We want you to go home and just think about this. If you need any information, let us know. We'll give it to you. So essentially, it's a stand down with pay.
Okay, that's good advice. The last one, Adele, is should an employer offer their EAP during the redundancy process, and perhaps at what point that should be done?
So EAP, that's the Employee Assistance Program. So a lot of medium and large size employers have these systems set up for employees to access free counselling. I would certainly offer employee assistance or this type of counselling as soon as the process starts. So when I say that, I should clarify. I mean, once the employee knows that there's a possibility of a redundancy, or once the employee is going through the organisational change and they know that there's potential for organisational change. Essentially, the end of just about every letter that I draft for employees ends with something along the lines of, and if you would like to access employee assistance, then please do so, and give them the details of it. I don't think there's any downside to offering it. Did you have anything to add, Anna?
Probably just to clarify, so you wouldn't offer it at the point when you give notice of the meeting? No, but in fact perhaps during that meeting.
Yeah, exactly. Yep. And if you don't have employee assistance program set up, then it's not too hard to try and find some short-term counsellors if that's what you need to do.
Wonderful, thank you. Well, I think that's all of our questions. I hope that information has been helpful for you today. And if you'd like to contact us further, the details are on the slides.
Thank you.